Thank you everyone for joining us tonight. We have a very special presentation with Susan Crocken and Dr. Sahar Wertheimer on the impact of the Alabama ruling on the future of IVF. A special thank you to our two sponsors tonight, Sharsheret and Joma, for helping make this possible. I'm going to begin by sharing a little bit of background of our two presenters here tonight. And I'm going to begin by reading their bios, and then we're going to jump straight into a few questions that we have pre-prepared, followed by opening it up to the audience for some questions. And for those who are just joining us, we are recording. You can keep your cameras on, only cameras are visible. Susan Crocken, JD. Since 1988, Susan has continuously represented individual and institutional clients involved in the legal, policy, and ethical dimensions of ART, assisted reproductive technology, and adoption. Susan established the Crocken Law and Policy Group, PLLC, in Washington, D.C. in 2012, following her move from Boston, where she had established a Crocken Law Policy Group, LLC, one of the country's first law firms developed exclusively to the legal issues surrounding assisted reproductive technologies and adoption. She has been instrumental in much of the developing ART law and policy in Massachusetts, including the Massachusetts Infertility Mandate. While in Boston, the firm represented numerous institutional ART clients, over 1,000 intended parents, donors, and gestational carriers, as well as 3 of the largest adoption agencies in the state. Susan has published extensively in the field, including on the Alabama ruling, and taught at law schools and on the undergraduate level as well, in the legal and ethical dimensions of ART and adoption. Susan is a member of the MA and DC Bar Associations, the MA and DC Women's Bar Associations, the American Academy of Adoption Attorneys, the American Academy of ART Attorneys, ASRM, SART, and she is a founding member and past president of the legal professional group of ASRM, past president of the MA Resolve chapter, past chair of the National Resolve Advocacy Committee, and past board member of the MA Women's Bar Association. Dr. Sahar Wertheimer is an esteemed obstetrician and gynecologist. She possesses a multifaceted approach to her medical practice. She prioritizes providing the highest quality of care to all her patients while supporting their fertility journeys with utmost respect and compassion. She's driven by her passion for educating women on their reproductive health, and she goes above and beyond her clinical responsibilities. In addition to her clinical work, Dr. Wertheimer serves as the chair of the Women's Health Committee of the Jewish Orthodox Women's Medical Association, JOMA. She has established a monthly webinar podcast and tackles various women's health topics, attracting a substantial audience of over 2,000 live viewers. Dr. Wertheimer is committed to advancing the field of reproductive medicine and is evident through her dedication research efforts. Her focus lies in genomics research, particularly exploring the epigenetics of the placenta, as well as identifying markers of androgen excess in polycystic ovarian syndrome. And I'm not even going to try to say that word. Can you say it for me?
I don't know what word it is. Polycystic ovarian syndrome?
No, HIRSUTISM.
Hirsutism?
Yes. Her expertise in these areas has led to her author and co-author publications that cover a wide range of reproductive and perinatal related topics. With her unwavering dedication and contributions, Dr. Sahar Wertheimer continues to make a lasting impact in the field of obstetrics and gynecology. So we are in good hands tonight in answering these questions, and I'm going to begin by laying the groundwork, and then Susan Crocken is going to give us an understanding of the legal implications of the Alabama ruling. So I am just going to start us off with that first question. Though tonight we are going to be focusing on the Alabama ruling, in order to get there, we're going to ask for a little bit of an understanding of how we got to this possibility of an Alabama ruling in the first place, by understanding how the Supreme Court ruling of Dobbs versus Jackson's Women's Health Organization laid and opened that groundwork, as well as understanding the legal concepts of personhood, and how this led to a personhood ruling in this particular case. So without further ado, Susan Crocken.
Thank you so much. It's a pleasure to be here. It's nice to see all of you, or to see those of you who I can't see. I teach this subject now.
That groundwork, as well as understanding the legal concepts of personhood, and how this led to a personhood ruling in this particular case. So without further ado, Susan Crocken.
Thank you so much. It's a pleasure to be here. It's nice to see all of you, or to see those of you who I can't see. I teach this subject now, and one of the things I thought would make it just easier to understand very quickly is as we race through this, is to give you a couple of slides so that you can see some of the things that the courts have said. So this is going to be a very, very fast overview. My students would love nothing more than if I would race through the whole semester in 15 minutes, but that's what we're going to do tonight. Okay, so I was asked to explain what the Supreme Court did in Dobbs and what the Alabama Supreme Court did in LePage. So here we are post-Dobbs, and the question really comes down to what are IVF pre-implantation embryos. And for those of you who haven't seen them up close, here you've got a picture of an embryo. Down here on the left-hand lower corner, you've got tanks. On the upper right-hand corner, you've got what I would say anti-abortion folks would like us to believe, that these are the unborn children in those tanks. And in the center is a Ziploc, what I call the Ziploc baggie, but it is really an artificial uterus with a lamb fetus, is wrongly saying that artificial uteruses are right around the corner. So that's what we're facing, if you will. Bear with me for just 1 second. Okay, so let's just jump right into what the Supreme Court did in our limited time, all right? So June 2022, the bombshell hits. The court is asked a question. Does Mississippi's law that prohibited pre-viability elective abortions, as in 15 weeks instead of 22 under Roe, is it permissible? So obviously under Roe it was not, so the court overruled Roe, and then it overruled the second case, Casey, effective immediately, and made a very clear ruling there is no longer a federal constitutional privacy right that covers the right to an abortion. The majority said this is a protection of an unborn human being. That's their language. They went on to say that abortion is inherently different and a unique act, and therefore this was not going to spill over into anything else, like IVF. They said, let's return the issue to the states. They ignored questions about interstate travel, about all sorts of overlapping and inconsistent state laws. Lastly, and this sounds very legalistic, but it's really important, they said, since it is not a constitutionally protected right, you apply what's called a rational basis test to any state that passes a law. Anybody on here who's a law student will tell you the first year of law school, what they teach us is if the rational basis test applies, that law is always going to be upheld. There is almost nothing that cannot be found to have a rational basis in the law. So kicking the constitutional right out meant that states were free to do whatever they wanted, including what Alabama did. So the first question we have to ask ourselves, I think, is abortion sharply distinguished from IVF embryos the way the Supreme Court would have us believe it? The words they use, I suggest, aren't. Abortion destroys potential life, what the law regards as the life of an unborn human being, and none of these other decisions involve that specific question. The dissenters very presciently said, what about IVF? What about things people don't think are abortion? The morning after pill, IVF, D&E, medication, and they argued that Roe and Casey were a very good balance. Obviously, as we all know, they lost. So that is the change in landscape that the Alabama court started. Before we get to Alabama, I want to take about 3 slides and 2 minutes to just give you the context of what happened, okay? Because the question is, at the end of the day, is what is an IVF embryo? As Gila said, when does life begin? The personhood movement, they all depend on when you say life begins. There is no single answer. It's always addressed by courts in the context of either a divorce or a misappropriated embryo or a lost embryo, as in this case. And the courts and the legislatures are asking questions about when does life begin? They use conception, which I'm sure you're going to hear from my other panelists, is not a medical term. Does it begin at fertilization, which before we had IVF, nobody had to think about the difference between those two? Does it begin at implantation? There are a lot of international standards that say at least implantation makes sense. At the end of the day, we used to have a constitutional right to privacy that was a negative right not to interfere with women's reproductive choice. We've never had a positive right to IVF or ART, but what Dobbs did is it took all that neck protection, swept it away, and there is no longer a defense to a state that wants to restrict other forms of reproductive use, if you will. Where we have gotten the legal standards and definitions of embryos comes from two types of court cases: patients versus providers, which is what the Alabama case is about, and what I call the divorcing line of cases. And we're not going to spend time on those, but that's where couples divorce and then they're debating who gets the embryo. And the courts have to think about, well, what is this that they're arguing about? So I'm going to skip the details because we can get to them in the Q&A if they're relevant. I really want to just give you a strong sense of the context and how Alabama and its progeny can be impacting us. So I'm only going to talk to you about one case in these 20-some cases that have happened about divorcing embryos because it's the first and the seminal case. And what happened in the Davis case for the very first time was a husband and wife divorced and fought over whether or not she could use the embryos or he could discard them. They did not have an agreement on record. The court said, what's the question? Courts always have to say, what's the question? The question is whether or not the constitutionally protected right to procreate and the constitutionally protected right not to procreate, what happens when they come in conflict? And the court said the husband wins. And what they said that was so important, I think, is this quote that pre-embryos, and there they are distinguishing an embryo outside the body from one inside the body, are neither persons nor property, but occupy an interim category that entitles them to special respect because of their potential for human life. Directly out of the first ethics committee of the what is now American Society of Reproductive Medicine. So if you pause for just a minute and look at that, what I think is so remarkable is the court understood and accepted the fact that IVF ex utero pre-implantation embryos are not like, property you can throw away, but they're also not like persons that you're going to tuck in at night and give full juridical protections to. And that special respect because their potential for human life puts them in a unique category. Having said that, it's also really critical to realize that the husband was allowed to discard the embryos because his reproductive autonomy and that of his wife's were in play and being balanced. At the end of the day, we have had over 20 courts since 1992 look at this question. We won't go into the details. You're not in my law school class, but the courts do not see these as unborn children. They do try to avoid labeling an IVF embryo. They talk about the rights they might have. They talk about it upholding agreements to discard. They get really nervous about procreation. It's remarkable when you look at that line of cases and think about what the court did in Dobbs, which was to say, once an embryo is inside a woman's body, we are going to force procreation. We are not going to respect the right not to procreate. But in the line of cases involving IVF, we have always protected that right up until transfer of the embryo into the woman's body. So question becomes, can you carve IVF out of what Dobbs has opened up, this Pandora's box? And I think it's really problematic, and I'll tell you why. Not only can a court do what Alabama did, but if these statutes that Gila referred to, the personhood statutes, the life begins at fertilization, then you've got a real question as to what other laws in that state will apply and restrict these use of embryos or discard of embryos. So a lot of people will look at a particular statute and say, yeah, we don't like the fact that it says it's a personhood law and that life begins at fertilization, but it only penalizes the doctors who do abortion, so we're safe. I would argue that many of those states were not safe, because if there's another one that says if you by mistake, negligently kill somebody because you drove too fast, whatever, that could be a negligent homicide that could apply to an embryo. Pregnant woman gets hit. So I think you have to look at the entire statutory scheme. A couple of states until Alabama had tried to exempt IVF. The Alabama Supreme Court ruled that frozen embryos are unborn children under its Civil Wrongful Death Act. We're going to get to that next. A couple of attorneys generals have said, we love IVF. This was before Alabama caused a firestorm. We don't mean to go after IVF, but I don't think it's as simple or as straightforward as they would like us to believe. This is a beautiful quote. It takes a minute to digest it, but basically this is a law professor who I think sums this up and says, if you could distinguish between the Supreme Court's rationale and IVF embryos, then what we'd have is a law that declares the sanctity of unborn life at the expense of the pregnant woman, except for when the embryo is not in her body. So we're not really balancing women's rights and fetus or embryo rights. We're just basically controlling women. So this carve out for IVF, I think, has got a lot of questions. So Dobbs came out and somebody said, what do you expect and what are you worried about? And I wrote this slide and I keep looking at it going, I still am worried about every single thing that I said in 2022, which is the state personhood laws are going to lead to enhanced liability theories if you lose, damage, or misdirect an embryo, and they might start applying wrongful death principles. Patients are going to move their embryos out of states with those restrictive laws. I think doctors are looking at more compassionate transfers, meaning transfer an embryo during a non-fertile cycle so that the woman doesn't get pregnant and they don't have to worry about disposition. I think a zealous attorney general is going to say, hold on a minute, that's killing an unborn child. You did that when you knew it wouldn't work. There are a couple of old states, we won't spend time on them, that have recognized some of these issues that lead to forced procreation. I'm not going to, I just want to mention Arizona. And for those of you who've seen Modern Family, Sofia Vergara and her ex-fiance are fighting. Arizona, we had an oncofertility patient who with her partner had agreed they would not use the embryos unless they both agreed at the time. At that time comes, he says no, she says yes. The court says, I'm sorry, we have to follow Davis, the right not to procreate. The Arizona legislature felt so badly that they passed a law that is on the books now that says in the future, whoever wants to bring the embryos to life should be the one who gets them. Doesn't matter what you signed at the clinic. And in the case of Nick Loeb versus Sofia Vergara, they also very carefully signed something saying, only use them if we both agree. Sofia broke up with him, didn't want to use them, and Nick Loeb says, hold on, I consider them unborn children. They're female embryos. We did PGT. I'm calling them Emma and Isabella, and they have a right to be born. And Sofia, if you don't like it, we'll force you to be an egg donor. That's the kind of skirmishes we were already seeing before Alabama. And I think that really is going to have an impact when ex-partners split up. PGT, we're already seeing a lot more of it because people are afraid of abortions. We're not going to get into that, except to say that I think if they're unborn children, the way Alabama describes them, there's going to be an argument that you're putting an unborn child at risk by performing a technology on it that may harm it. And if you can't discard it, what are you doing it for anyway? So those were some of the problems that we saw. Here, let's get to Alabama, okay? So LePage is a case, and I've got 2 quick slides on this, which will summarize them. There had never been a successful lawsuit against providers for embryo management under a Wrongful Death Act before this. What happened? This IVF clinic was embedded in a hospital. There was a psychiatric patient from another part of the hospital, wandered into the storage facility, which was shared, and somehow got into a tank, pulled out the embryos, dropped them in the freezer, frozen test tube, burned his fingers, and damaged and destroyed the embryos. These 3 couples who sued were all successful IVF patients at the clinic. They each had 2 IVF children. What happened was the only way they could get a lot of money called punitive damages was under the Wrongful Death Act, and their lawyer recommended, I'm sure, let's try to use that. And what's wrong with that? Let's argue that we can't discriminate on the basis of where an embryo is, in the uterus or in the petri dish or in the freezer. The court knew where it wanted to go. This was an incredibly religious, Christian religious-driven court. The red here is how they frame the question. If you just read it, you know what the answer is. The central question involves the death of embryos kept in a cryogenic nursery and whether there's an unwritten exception to the rule for ex-uterine children, unborn children outside of a biological uterus at the time they are killed. There is no way this court is not going to come out the way they come out. So what they did, in short, is they said that their civil law, now this is a civil law, not a criminal, it applies in Alabama, nowhere else, written in 1872, was clearly intended to apply to IVF embryos as unborn children. It would be discriminatory to not treat them the same as you treat other embryos because they're in cryogenic nurseries. But if the Constitution isn't clear, they would the rest of their laws would require it. The court went on and misstated and criticized current US IVF practices because they said too many embryos are created, frozen, and planted. They then said, let's look at Australia and New Zealand. They don't make as many embryos as we do. Not true. They said children who were born from artificial uteruses would be unprotected because they never got in one, suggesting that was around the corner. And they basically said the consequences, the policies are not relevant for us. And then this is the scary thing about Alabama. What they said is, legislature, knock yourself out if you want, do what you want. But any law you pass has to be consistent with our Constitution. And we've just told you what it says. I want to point out, this is the second and last slide on Alabama. The Chief Justice's opinion is the one that has gotten the most notoriety. It's a lengthy concurrence. I think there were over 41 references to biblical and religious sources. He says human life cannot be wrongfully destroyed without incurring the wrath of a holy God. And even before birth, all human beings are in the image of God and cannot be destroyed without effacing his glory. Now, I want to read you one thing that he said I didn't put on the slide because it's really important to how we go forward, which is other westernized countries have adopted practices in IVF that allow it to continue while drastically reduces the chance of embryos being killed, whether in the creation process, the implantation process, the freezing process, or by willful killing when they become inconvenient. Okay, so that is his view, and it's a pretty startling one, if you will. The dissent takes him on. Scathing criticism and says, you all misread the law. You're not lawyers listening to us tonight, so I don't want to go into the nitty-gritty. But what they said is this ends the creation of frozen embryos in Alabama. No doctor is going to rely on agreements if you think these are unborn children. Then he went on, and this was really fascinating, to say everybody here agrees that an embryo is a life, which I think all of us here would not necessarily agree with. But the question is it an unborn child under the Wrongful Death Act? And the answer is no, for a lot of very good reasons, and then says equating an embryo in a specialized freezer with a fetus and a mother is an exercise of results-oriented intellectual sophistry. Long story short, as you all know, the case has gone back to, well, you may not know this, but everything stopped in Alabama. The case has been sent back to the district court. We can talk about why. I don't think we're going to get a lot of satisfaction there. We are going to get satisfaction in part from the statute they passed. So I want to look at that really quickly before I stop talking. The Alabama legislature passed a very quick law in order to get back to work, clinics back to work. And outside of Alabama, you've just seen it. It's been all over the map in terms of states trying to legislate. So this is really fine print. Let me just tell you what's important here. The Alabama legislature passed what they admitted was a stopgap law. Here's what it says, the first two bullets. It grants civil and criminal immunity to any individual or entity in connection with the death or damage to an embryo when providing or receiving IVF services. Bottom line, it's a get out of jail card free for doctors, and it does not protect patients whatsoever. If anything is going to go wrong in that process, they have taken away all liability. A lot of Alabama legislators expressed concern. I'm not going to go into the details. The Republicans realized it was stopgap. They rejected a Democrat bill. One Republican said he didn't like even this bill because the routine destruction of embryos was akin to the Holocaust. Yesterday, as I was looking at my slides, I found out that Kentucky just passed a law. It was signed by the governor last night. It's a very different but similar protection. It says, notwithstanding any other law, a healthcare provider shall be immune from criminal liability for any act or omission relating to health services, but it does not stop them from negligence. So that leaves patients with some remedies if they need it. Ironically, yesterday, one other thing happened, which was remarkable, which is an Alabama state legislator, a Democrat running for a special election, flipped a seat, running on IVF and reproductive rights by 62 to 38%. She got 44% of the vote the last time she lost. So my last slide, what's keeping me up at night? This is what's keeping me up at night in this topic. I think frozen embryos are the first easiest target for anti-abortion, anti-IVF zealots. We love babies. We love baby makers. We just want you to change it a little bit. Make one embryo at a time. They really like embryo adoption. One of the sponsor of the bill, I didn't show you on that slide, says, I already have one 6-year-old from embryo adoption and we got triplets on the way. Multiple embryo transfers to avoid frozen embryos. All of that would essentially be a change, and I would suggest a very big step back in standard of care. And I think it's based on two things: a lack of understanding of the medical reality, and then for some people, it's an intentional anti-abortion agenda. It's certainly a loss of autonomy. It's the Sofia Vergara problem. Okay, you don't want those embryos, eggs, or sperm, give them to somebody who does. And I think more states are going to look at Alabama as Gila asked, what do we think? I think the red states who don't like IVF are going to try to, who don't like abortion are going to try to protect IVF the way they are. And I sort of worry that this is a gateway drug into more and more restrictive legislation. So I'm going to stop. I'm looking for answers, questions. I know there are lots of them, but what I want to do is hear answers. I'm going to stop screen sharing. Thank you.
Okay, so I'm gonna go in and give us the medical before we open up questions to everyone. So Sahar, sorry, Dr. Wertheimer, do you mind explaining for those of us who are here who don't fully understand the concepts of IVF, so that we can fully understand what Susan just explained to us, a little bit more about what this actually means? So can you give us a quick overview of what IVF actually is, and then what the embryo is that is being impacted, and if indeed scientifically it is considered human life?
Yeah. So first of all, thank you, Susan. That was very thorough and it gave me a lot of insight. And I had a couple questions and gaps that I was like just needing to fill in. And I still have a gap surrounding how that psychiatric patient got into the embryo, the nitrogen tanks. I'm just floored by that. I think that's one piece of the puzzle that we're all kind of like confused about and moving over, but it's just so crazy to me. Our embryos are under lock and key, video surveillance, a million alarms. So that's interesting. And then I was kind of interested in how how they recently protected the doctors in Alabama. So I can tell you guys about IVF, and I am qualified to speak on this because unfortunately my bio, which is on the website of HRC, does not say that I'm a reproductive endocrinologist and a fertility specialist, which is interesting. So I do IVF all day, and basically what I've said before is that nobody knows better than a woman suffering with infertility that an egg or an embryo does not equal a child. So in IVF, it's all kind of, we're taking advantage of statistics and of a funnel mechanism where we try and stimulate a woman to give us as many eggs as she's capable of giving in 1 month. So normally in a natural cycle, a woman is taking from this background group of eggs. One egg becomes her dominant follicle that she is going to ovulate that month. The rest of the eggs kind of get repressed and then resorbed by the body. In IVF, we stimulate that whole cohort of eggs to become dominant or mature follicles. And then we take them out in surgery. We then fertilize them. We grow them to embryos in the lab. So that takes about 5 to 7 days. And then from those embryos, a very common standard of practice now is to PGT test them. So to genetically biopsy them and see if they're normal or not normal. And then once we have the normal embryos, we can begin the process for transferring the embryos into the uterus, usually 1 by 1. So at every point in this, like from the moment we see how many follicles she has on her ovary to how many actually stimulate and come out, about 70% of those eggs will fertilize, about 50% will make it to the embryo stage. And once you have a clinically tested normal embryo, it has about a 60-70% chance of implantation. So statistics are not 1-to-1 embryo to child. And I think that's where, a lot of the unborn child potential, sure, it's potential. And I feel bad for these families and what happened to them, but they are not children.
Amazing. Thank you for explaining that. So Susan, I have a lot of follow-up questions for you, and my brain's going to continue to have questions for you for weeks and weeks to come. Thank you for really taking the time to really explain that. I know that you mentioned well, in all of this, we've established that embryos are not life. And you started to touch on this, and I'm not sure I fully understood it, and I'm sure that there are questions about this in terms of legal theory that you were starting to address, in how, though fact and science states that embryo doesn't equal human, that theoretically speaking, we can talk about embryos as being humans. Can you explain a little bit more about how theoretical law becomes practical practice, even though science refutes it?
Sure. I can explain it, but I can't justify it.
That helps.
So if a court pronounces or a legislature drafts and enacts a law, it is the law of whatever the jurisdiction is. So when the Supreme Court says there's no right to an abortion anymore, it applies to the entire country. When the Alabama Supreme Court says it's an unborn child for purpose of this law, that applies. And when the legislature passes something, that applies. It doesn't have to be scientifically accurate. And that's one of the things that has bothered many of us in the personhood efforts for so long, because this person begins at fertilization is not what I don't think any medical scientist would agree. And yet, if they put it into the law, then it is. And I don't even think some of these state legislators who are using the terminology mean it. I mean, the Republicans in Congress, asked to pass a law that says life begins at fertilization, and they all came out and said we love IVF.
Right.
So, law should, but does not have to be, grounded in scientific and medical accuracy.
Oh, thank you.
Is that what?
Yes.
Is that what you wanted?
For clarifying that. So back to the medical question. If that is the case and personhood bills are upheld, you were starting to explain, Dr. Wertheimer, about the process of doing genetic testing for the purpose of ensuring that either if one has a genetic disease that they do not want to pass down, those embryos are being selected out, or for aneuploidy embryos. How would personhood bills now impact access to IVF care in that space? And yeah, I guess that's the question.
Yeah, so, and Susan touched on this in her PowerPoint, but I would say that where we as medical professionals are very concerned is, as I mentioned, right, all of IVF kind of is dependent on this wide funnel eventually making its way down to these, fit embryos. And so what I'm worried about is kind of at every step in that process. Are they going to tell us, we don't want you to create so many potential children because only one of them is going to be transferred, or what's going to happen to the rest of them? You're eventually going to have to discard them. Are we going to have to fertilize one egg at a time, or even stimulate a woman to have just one egg at a time, a natural cycle, fertilize that egg, get it to the embryo stage, see what happens with that embryo first, and then try and go for another one? And I have had Catholic patients before that have asked for, a softer stimulation. They didn't want to create so many embryos where they didn't know what they were going to do with it. So I can see that becoming a reality. It's one thing if the couple says, we're going to spend the money, that's our choice. And it's another thing to tell another couple, this is what you have to do because your state is mandating it. And the concern with that is time, right? A lot of these women are already racing against the clock. The biological clock is very real. If we're going to make her, one embryo every month until she finds the normal one and gets pregnant with it. And what about baby number 2, right? Because then she can't even store embryos for baby number 2 until she's older. Then we're losing time. And the other one is expense. IVF is very, very expensive. And to take somebody through an operating room procedure and a lab procedure, we're now trying to we currently have like a deal at HRC where we try to batch embryos together and then send all the biopsies at once to reduce the expense of the genetic biopsy. This is like going in the total opposite direction. So time and expense is my concern at that stage. And then are they going to even allow us to genetically biopsy these children, right? And if they do allow us to genetically biopsy them, what happens to the abnormal ones? Are we allowed to discard them? Do we have to, as Susan wrote in her slide, compassionately transfer them? Meaning, do we have to transfer them to the uterus out of compassion because this was a life and we need to give it a shot, even though we know it's probably not going to work? And if it does work, by the way, there are some, as we know, like children with Down syndrome, for example, are compatible with life. They're an abnormal embryo, abnormal chromosomes that are compatible with life. And Down syndrome is very compatible with life, but there are some syndromes which are much worse and they end up dying in utero or being a miscarriage. Are we going to have to subject women to all of these things because we don't want to discard these embryos? So these are all, these are like kind of the most fundamental, largest, I think, weighty questions that we have. And then, of course, there are the other ones about embryos crossing state lines, embryo adoption, all the other stuff.
And just to pause here and differentiate between embryo adoption as it was used versus embryo donation, legally, and I think within the world of donation, there's a big difference between the religious right desire to have embryos adopted versus the compassionate choice of a family who has extra embryos who choose to donate gametes. And how that differentiation in the wording means something, and just to be mindful of that for those who are coming to it from the perspective of embryo donation, knowing that it is different than what is being forced here as embryo adoption. I guess
I don't think I could speak to that. Maybe.
I'm just stating a difference.
Oh, okay,
in language. There is it in terms of PC language. There is a difference in the use of both. One is a choice. One is forced by the religious right. But if Susan, if you did want to speak to that, I wasn't.
Well, the only thing I would say is that I think embryo donation is the accurate term, but there is at least one state that talks about embryo adoption, and I think it's a very intentional language choice by anti-abortion advocates that they've been using for years to try to personify embryos and humanize them so that we would think of them as unborn children. And, I could draw a through line, if you would, through that language to others. So I agree with you about what is the accurate, with the exception of a very, very tiny number of states. But when I see a representative in Alabama say, I'm proposing this legislation, and I'm sorry, in Kentucky, I think it was, I'm the proud dad of an embryo adoption, and I'm hearing it since Alabama, I'm hearing it more.
Yeah.
And what's worrying me a lot is that it is some effort by those who oppose abortion but want to support IVF to thread the needle and to come up with some way that they can say it's okay as long as embryos that are left over are adopted. And not only are you correct, or I agree with you on the language, but am I pronouncing your name right, Sahar?
Yeah.
Okay, sorry. Okay, thank you. To Sahar's point, it also means that these embryos, you can't do what is medical standard of care with them. You can't let patients choose whether they want to have an embryo with Down syndrome transferred or not. You can't choose whether they want to discard them if you go to the end of this road. You can't choose, the husband and the wife who disagree, no matter what they decided before they started, it's going to be whoever wants to bring them to life. I think the end of this road is, okay, neither husband or wife wants them, fine. We have a lovely couple over here who would be happy to take them.
Right.
And that's actually been the law in Louisiana for a couple of decades. What people do is they ship their embryos out of that state, as I understand it. But that could be a very predictable endpoint if we keep down this road.
Mm-hmm.
Are there
and for couples with genetic mutations who are specifically creating they are fertile and they're specifically creating embryos to avoid a genetic disease in their offspring? Is that going to be allowed, right?
Yeah, I mean, it will be allowed unless somebody says IVF is dangerous. IVF, if they outlaw IVF, which I don't see, or they say you can only do it for certain reasons. I don't see that. What I worry about is somebody saying PGT cannot help this embryo. All it is doing is helping these parents with information. So why would you do PGT? And if you do and you don't want those embryos, you can't discard them, because how can you say an unborn child is worth more or less if it has an abnormality or doesn't?
Right. Yeah, I think that what I'm talking about, the single gene mutations, that's a PGTM case, and those are even more gray because those children are much more compatible with life than, for example, a chromosomal abnormality. It just might have a enzymatic disorder that will make its life terrible. And so I think that could be a really gray area as well.
And I think
Agreed.
to speak to the audience that we have here from Sharshara, it is for individuals who are testing for BRCA mutations, the BRCA, and wanting to not pass that down to the next generation and using IVF as that way of protecting them.
Yeah. Mhm.
Okay, we have a few more questions. I'm gonna wrap it up because this conversation has been amazing, but I know that there are individuals in the audience who have questions as well. I think that the final question that I wanna leave us with is that I know we're speaking about the possibility of losing access to how we do IVF, but not necessarily fully losing it. Are there ways legally that, like this new law that has been passed, this new bill in Alabama that has been passed, to protect those who are providing services, whether it be the doctors, the lab technicians, individuals within the field? Are there other ways in which we can protect IVF from personhood bills preemptively?
The question for Susan. She started talking on it at the end, I think.
I mean, let's be clear that this is a problem in states that have those laws. So one way to protect yourself is to do your treatment in a different state, if you're
Yes.
fortunate enough to live in a state where you don't have to worry about that. The other is,
California.
the other is advocacy efforts to get these laws kicked off. I have always said that I think people should testify and be willing to go into these state legislatures, go beyond, get past your comfort zone and go in there and explain to these legislators what fertilization is and isn't, and what an unborn child compared to an embryo. I really do think that some of this is built on ignorance. I heard somebody, I think it was Elizabeth Carr, testify, the first IVF baby in Congress, and somebody asked her what an embryologist was. So, it strikes me that some of these people who say life begins at fertilization and who write those laws and try to get them passed haven't really thought about this. Or some of the medical facts Sahar mentioned about, how far you are from a fetus with this. So once those laws have passed, I think you can lobby attorneys general, and you can, to say don't go after people for IVF. I don't think people want to. We're seeing the firestorm. But I don't think we can protect them unless these laws are not there.
For sure.
Yeah, so I think that's why what you're doing, Gila, is so important, because traditionally, I think Orthodox Jews may also, I think we're doing a great job of raising awareness, because I think we instinctively want to preserve life, and that also leads to some ambiguity in the anti-abortion laws, where it was a lot of needing to educate that if you are anti-abortion, you're not going to get your medically your medical termination that your rabbi sanctioned, right? In the process of causing some of these laws, you are losing some religious freedom. And I think it's the same thing here. Now, I think a lot of us really doubted whether we were going to see these anti-abortion laws extend to preconception and embryos, and a lot of people didn't believe it. And here we are. So we do have to do a lot of advocacy and a lot of education. I have a personal thing that I like to just say, because we are living in unprecedented times, and a lot of us put our Jewish status really high up there. And unfortunately, these days, the people who are advocating for pro-abortion, pro-choice, pro-IVF are on the opposite side of the political spectrum of, some of where I think our existential threat lies these days. So I think we have to be really careful. And this is why women's rights should not be politicized. And we have to be careful who we give a platform to, and be really discerning in both directions.
I also think it may be as obvious, but I think it bears saying that these laws are so reflective of one religious perspective and so disrespectful of those of us who don't share those religious beliefs. And it's just remarkable if you read like the Alabama decision and other cases that people are imposing their religious beliefs on
On
those
other
of us who
people,
don't
yeah.
share them. There are some lawsuits with patients who are trying to challenge them. So when you say, what can you do? There were a group of Jewish women who were bringing a lawsuit trying to say, this is, just not, this is encroaching on my religious freedoms. Those
Yeah.
lawsuits, I don't think are going anywhere, unfortunately. They should.
Yeah,
They
why
should be
why
going
don't you
somewhere.
think they're gonna go anywhere?
And I hate to say this, but the Supreme Court got amicus, friend of the court briefs on all of these issues in Dobbs, and we're not persuaded by any of them. So if the Supreme Court can do it, I don't know why the lower courts can't. They ignored this separation of religion and law, and they did it themselves. And that's why I'm just, I'm pessimistic about the lawsuits. I'm
Mhm.
hopeful, but I'm pessimistic, I guess.
Mhm. Mhm.
I'd like to be
Yeah, because
wrong.
that's always been like an area for me that I'm always very curious about. It's like some of these laws are truly encroaching on your religious freedom, and I don't see how that's allowed. But maybe it will
Yeah.
take a famous case to get there to set a precedent.
Yeah.
Somebody's asking a question, Mila.
Yes. Who submitted amicus briefs? That piece was
Um,
there. You had mentioned the amicus briefs that were submitted by the multitude of Jewish organizations and others during
Yeah.
Dobbs. Do you have any
I
examples?
don't, I don't, but it'll be a matter of public record if you just go and Google for the Supreme Court's website. They have to list all the amicus briefs. It's probably on the Dobbs opinion itself.
And can you just explain for those who might not understand what that is, an amicus brief?
Oh, of course. I'm sorry. Of course, amicus is Latin for friend, and the friend of the court. I think I don't speak Latin, but basically, when a case of importance goes up to an appellate court, people who think they have a point of view that the court may not be hearing from the parties are file these briefs that are friend of the court, saying basically we just want to tell you the facts. So, for example, in the Alabama LePage case, the Alabama Medical Association filed an amicus brief. I wish SART, the American Society of Reproductive Medicine, had filed an amicus brief explaining what the medical facts are. So in Dobbs, many interest groups filed friend of the court briefs, and it's basically a chance to argue your organization or your principles to them. It's not supposed to be an argument, but they often are. But it's basically, let me just explain a point of view that you may not be hearing otherwise. And I know religious groups did it. Which ones they are, I can't tell you, but they'll be on the opinion.
Thank you. I'm going to stop the recording. Oh, we have another question here. What about new law in Alabama versus what the state Supreme Court said? How do they reconcile?
They don't. I mean, I'm just going to be really opinionated. I think here's the problem. The Alabama Supreme Court says these are unborn children. And the law says a doctor who drops an unborn child is going to be immunized from liability. So how do you immunize somebody who kills an unborn child if you're going to be really graphic about this? So I think there's a problem. But who is going to challenge this? Somebody is going to have to feel so strongly about the Alabama Supreme Court's view and wanting it that they're going to have to bring a lawsuit at some point saying, I want to challenge the law. So I think what's shocking to me is that in a temporary basis, people in Alabama are like all going, great. We can now go back to IVF practice. The clinics are open, transfers can happen. But that I think is the problem. I don't think doctrinally they are consistent, but it would take a very unusual fact pattern to get this back to the court.
We have another question of what could the implications be in terms of donor eggs, donor sperm embryos that have already been donated to a couple but will not end up being used? What are the risks to third-party reproduction? So I think before we even ask this question, I'm going to break it up into two questions. Firstly, can you differentiate the difference based on this ruling between gametes of eggs and sperm that are not yet brought together versus that of an embryo that has created what the person Bill is now stating is a person, in terms of the implications of this? And then are there risks to third-party reproduction?
Is the first one a medical question?
I guess so, yeah. Or legally, is there a difference between
Oh, yeah,
sperm
okay,
and
so,
egg
I mean,
legally under the law, since they have not yet formed
yes, most people,
fertilized?
most courts and laws that you see around the country define eggs and sperm as property. And they're usually under the control of the person whose property it was, or if you donated them to the recipient. Embryos are not considered property for the most part. And the argument we're having now, and this whole thing is built around, is are they unborn children? There's a continuum, eggs and sperm property, put them together. I would say that's potential for life. That's the special respect category. The Alabama Supreme Court has said those are unborn children. And the Supreme Court has said once they're in the uterus, they're unborn children. So there's the problem, if you will. It's a much bigger discussion about how, if and how this affects donor eggs, sperm, and embryos. I think what you have to think about is, first of all, donor sperm and eggs hopefully are still at the bottom of this fight, if you will. Embryos are at the top. And donor embryos, I think a couple who receives them, as you asked me, and doesn't want to use them, I think could be subject to the same question of can they discard them, or do they have to be donated to somebody else or given back to the original people? In Louisiana, there's a really weird law I told you where embryos are juridical persons. If you don't want to use them, they revert to the doctor as the guardian, and he or she has to find them a new home, and it says with a heterosexual married couple. So I
That's
think,
Louisiana, you said?
yeah.
Wow, I would never want that liability.
Can you imagine? You were I say this to the doctors all the time. It's like, congratulations. Did you know you were a guardian?
Wow.
And you can't give them to a single or a same-sex couple, or, it's just,
That sucks.
Do they, so in Louisiana, they're probably moving the embryos out of the state or no?
I think most patients move them out of state or they
Yeah.
ignore it. But I think most patients are advised to move to long-term storage to a more favorable state.
Mm-hmm.
But it's crazy because that's been on the books forever.
Wow.
Can
I did not know that. I didn't know that.
I ask a follow-up question to this? We keep talking about transferring versus discarding. What about freezing
Donating to science.
or freezing indefinitely? Because donating to science, I would assume, is tantamount with discarding. But what about freezing indefinitely?
Yeah. I think a
haven't
lot of couples,
changed
I
it
think a lot of
stack-
couples end up freezing indefinitely because they don't want to get rid of them anyways.
Is there legally a protection to freeze indefinitely in states that have personhood?
Yes, but the problem is, and Sahar can speak to this, the doctors then end up holding the embryos. Patients have to either pay or stop paying, and even if they stop paying, the doctors are probably afraid to throw them out. So then you've got this indefinite storage, and we're almost replicating the problem we had from the 80s, which was when we started freezing embryos and didn't realize we needed to have dispositional agreements so that people wouldn't disappear and abandon or leave their embryos without instructions.
Yeah.
So you could do it theoretically forever, but one of the quotes that I raced by on my slides was the sponsor of the Alabama law said, well, there's some unanswered questions. Like if you take an embryo out of the freezer after 30 years, is it 30 years old and can it go get a driver's license right away? I mean, so
Did
yes,
you
you could freeze
see,
indefinitely, but it's not it's sort of a kick the can down the road situation.
we want to know if couples in Alabama can claim their embryos as their dependents. What do you think?
I think people are going to try it. They were trying to get HOV lanes
Yeah,
approved by
HOV
pregnant
lanes, I
women in
remember.
Texas.
Yeah.
And, Gila, a more practical on the ground option is to send your embryos to long-term storage in a state that doesn't have those restrictive laws.
Yeah.
Are there still restrictions of getting them out of Alabama? There was a time at the very beginning, companies refused to move them. Is that still an issue?
It was never the law, it was their liability. They were worried about if they were unborn children and something happened to the refrigeration, they couldn't take the liability, but now they've been excused of liability. So I'm guessing, I don't know this for a fact, but if the IVF clinics are back up and running, I suspect all the shippers are too. And it wasn't all the shipping companies who did it. So I don't think there's anything that would stop a shipping company from doing it who wanted to do it.
We've 2 more questions in the chat. I'm noticing the time. I'm gonna quickly close up with these 2, and then we're gonna end for tonight. This has been such an incredibly nuanced conversation. It's been so involved that I didn't even realize how much time we have spent on this already. And I'm so grateful to both of you for really giving us so much of your time and longer than I had even asked. Can a state forbid a patient from moving embryos if the state law deems them person? So I think that's a little bit of what you were talking about now in terms of liability.
Yeah, so I don't mean to scare people at the end of the hour, but I'll just say, like, probably not unless somebody wanted to really make a test case out of it. What worries me is if a husband and a wife disagree and one of them wants to do something with the embryos and the other doesn't, that's going to be a great argument. Just like I worry about surrogates crossing state lines to do an abortion if that's what's been agreed on. And somebody saying, yeah, you have a right to travel across state lines, but that unborn child you're taking with you also has a right not to travel and not to be killed. So no, you can't go. This whole right to travel is a pretty undeveloped area of the law, is the short answer. It's not satisfactory, but it's a short answer. It would be hard pressed for me to think a husband and a wife who agreed in a clinic who was willing to do it, that an attorney general in the state is going to come up with this is the test case they want to bring.
Yeah.
I hope.
Yes, let's hope that this doesn't come to that. And the piece on advocacy, and I know that we briefly mentioned it, but Resolve has been working tirelessly to ensure that none of these personhood bills are being passed, and rather that there are bills being passed to protect IVF. And we all have the opportunity, whether it is through sharing our own stories, if we have gone through our own fertility journeys, or speaking of voices of individuals who haven't and who are standing as allies beside those who have and will in future. And our final question of what about compassionate transfers? I'm assuming this is a legal question. I know that, sorry, you touched on the
I'm not sure.
concept
Do
of
you know
it.
what the question is? What about compassionate transfer?
I'm assuming is, will they remain legal because they have no potential,
transferring an embryo knowing it won't.
knowing that it has very limited potential to present into real life or into a pregnancy. I know that it's not 0%, but the statistical probability is very low that a compassionate transfer pregnancy.
I sadly think it's a great test case.
Uh-huh.
Why would what a doctor is literally, I mean, the definition, Sahar, correct me if I'm wrong, of a compassionate transfer is so that you don't have to discard the embryo, but you don't have to worry about this becoming a child. I know there are a couple of cases where, I know there are reported cases where it has come to life, but to me, that's a very easy legal argument for somebody to make. You're doing this not for the purposes of helping this embryo be brought to life as it deserves.
Right, especially because for a transfer to work, you have to prep the uterus, or the woman has to be in the right phase of her cycle. And I don't know that they're going to go so far as to demand how that transferring of the uterus. Compassionate transfer is a transfer that you're basically doing because you know it's not going to work, whether it's because the embryo is just so not compatible with life, or if it's because you're doing it in a uterus that's not prepared to accept a uterus. So,
and you don't do any of that prep work, right?
Right.
Right. So to me, if I was the doctor being asked to do that in a state that was really aggressively going after this stuff, that would give me a lot of pause. I would be very uncomfortable because it's so easy to prove.
Yeah. I think people easily disregard that there are other risks inherent in some of these things, right? I have to say a compassionate transfer is probably super low risk, but it's an intervention, and that's unfair. Pregnancy is not a health neutral state. Pregnancy is a risk to a woman, even in the best case scenarios. And so to have a woman have to carry a child to term, or even to carry a child, period, that is going to be, that might die in utero, that's putting her life at risk. For not a great outcome. So I think that's the part that's also so discounted by some of these, unfortunately, by these lawmakers.
Yep.
Thank you both so much. Thank you again to everyone who joined us, to Sharsheret and to Joma for co-sponsoring this event. This has been wonderful and so insightful, and I'm sure opened up so many more questions for everyone. So appreciate you both making the time.
Well, thank you for
It was,
having
it
me.
was so nice to meet you, Susan, and Gila, thank you for all the advocacy that you do all the time.
Thank you both.
Exactly.
Bye.
Good night, everybody. Take care.